This is Nick Novotny and Zach Cothran talking about the process of trials and the roles of the attorneys. So in the American justice system, we have the adversarial system of resolving disputes between two parties. These two parties are the adversaries. They are the accuser and the defender on the right side. Both of these parties are made up primarily of the person with the complaint in terms of the accuser and the person defending in the defendant. So these are the main portion of the defense and attacker, but they also have the option to hire an attorney each, if necessary. And those attorneys fulfill roles that Zach will talk about in a minute, but the third primary actor of the trial is the arbiter. The arbiter is the person to mediate between the two parties and to decide. So the arbiter in civil trials is just the judge, which the judge proceeds, the judge manages the trial and ensures that each side lets the other have their say and ensures that, and then of course hands down the verdict at the end. But in the case of a criminal trial, the arbiter is actually two actors in itself. It's split in half. The jury, which actually hands down the verdict to the judge, and then the judge announces it, and the judge itself, the judge him or herself, which the judge at that point basically focuses on the process of the trial. So now we're going to get to the roles of the attorneys, and Zach will talk to you about that.
Okay, dealing with the roles of attorneys, the attorney would have to serve the client as they would themselves within the bounds of the law. They also need to ensure client confidentiality, which basically means anything the client says has to be, kept safe. Just saying, like terms of a, if the person is guilty and they say that they're guilty, the attorney still would, defend them if they would like to go through as being innocent. Funny how that goes, but the attorney talks to the arbiter on behalf of the client, and that may entitle like a moderator or something, and like for civil, like divorces or something close to that. I would talk to the judge on behalf of the client. Courtroom involve like giving legal advice, drafting contracts, negotiating agreements, helping the client solve legal problems, just helping their client make the right choice. If they have a good deal and the client is guilty and it looks like they are going to be convicted of being guilty, hey, you might want to take the deal. It's probably your best option. Kind of hearsay of helping out the client. Actual full steps of the trial.
So in the beginning at the trial, each side makes an opening statement. The first person to go is the accuser. So the accuser will make an opening statement detailing what the offense was, how the defendant broke the law, and will detail sometimes the case that they will try to make in the opening statement. And then at that point, after the accuser makes the opening statement, then the defense will make a corresponding opening statement. But in the defense's case, they basically try to poke holes in or say how the defendant did not commit the crime or break the law. However, the important thing to notice here is that overall, the burden of proof is on the accuser. The accuser must prove beyond a shadow of a doubt, according to the Constitution, that the defense broke the law. So, in essence, as I say, the jury or the arbiter, the judge, is looking to the accuser to prove that the defense did something wrong. Statements, the accuser will call witnesses to support their opening statement, and then each witness, the defense has the option to cross-examine the witness to whether they saw events clearly or try to prove that they're lying or something of that nature. Then, after the accuser has called all of their witnesses that they wish to call, the defense can either side can put forward motions to, for instance, if the defense believes that the accuser has not brought forward enough evidence that the defendant has committed a crime, then the defense can move to dismiss the trial. Decide on that. Now, at this point, the defense can call their own witnesses to the accuser's case or to present an alibi for the defense. And then at that point, after the defense has called each witness, the accuser has the ability to cross-examine each of those witnesses. And then, once the defense has called all of their witnesses, can make a closing statement, followed by the option from the defendant to state a rebuttal of the accuser's statement. And then after that's through, the defendant makes their closing statement, and the accuser in turn has the ability to rebut the defendant's closing statements. And then at that point, the arbiter, if it is a civil trial and it is just the judge will go and deliberate on all of the arguments made in the trial and return with a verdict in some point of time, which is dependent on the trial and the arbiter. But if this is a criminal trial, then the judge will instruct the jury, telling them the guilty or acquitting the defendant, and then also when the jury returns with a verdict, will read the jury's verdict and sentence the defendant if they are in fact proven guilty. And that will conclude the trial.